of Studies and Divisions, ladies and gentlemen. On behalf of School of Law, it is a pleasure to extend a very warm welcome to you on the Constitution Day celebrations. Constitution Day or Samvidhan Divas is celebrated on 26th November every year to commemorate the adoption of the Constitution of India. This is a day to express our gratitude to the makers of the Constitution and to reiterate our commitment towards the building of the India of their dreams. The Constitution of India was not typeset or printed, but it was handwritten and calligraphic in both Hindi and English. We have the replica of the original Constitution with us today. I request Dr. Sunil Srivastava, Director, School of Law, to present the replica to the Honorable Vice Chancellor, Professor Nageshwar Rao. I now request you to present the preamble to the Honorable Vice Chancellor. Thank you, ma'am. May I request you to deliver the welcome address?
Honorable Vice Chancellor, Professor Nageshwar Rao ji, honorable guest and expert for today, Shriman P.K. Malhotra, former Union Law Secretary, PVC Professor Satyakam ji, PVC R.P. Das ji, Director, Registrar IGNOU, B.P. Negi ji, Directors of Schools and Divisions, friends, learners, ladies and gentlemen. I feel honored to welcome you all on the occasion of Constitution Day, which is celebrated on 26th of November every year. As we all know, that Constitution Day or Samvidhan Divas, also known as National Law Day, is celebrated in India on 26th November every year to commemorate the adoption of the Constitution of India. On 26th November 1949, the Constituent Assembly of India adopted the Constitution of India, and it came into effect on 26 January 1950. The Constitution of India is a many-splendid document, grand in its vision, deep in its import, both the fundamental law of the land as well as the manifesto of the nation's socio-political destiny. It is at once a framework for governance and an instrument of empowerment for the common citizens of India. The Constitution consolidated the gains of a freedom struggle and incorporated in it the aspirational seeds of a young nation's growth and development. The founders of the Constitution were keen that the history and heritage animate the pages of the Constitution of an independent India. Accordingly, the services of Acharya Nandalal Bose of Shanti Niketan were engaged. The original Constitution of India, as adopted on 26 January 1950, was a handcrafted work of art with illustrations by Nandalal Bose and calligraphic text by Prem Bihari Narayan Rajada. For embellishing the chapter headings and several margins of the Constitution, Acharya Bose took inspirations from the genius of the grand artistic tradition of India, including Ajanta and Badmirez, miniatures traditions as well as from folk art. These vignettes from various aspects of Indian history and culture form a rich pictorial depiction of a tradition and heritage. The Vedic period finds representation in the scene of Gurukul, as does the iconic image of Lord Ram returning to Ayodhya after his victory over evil, along with the image of Lord Krishna giving the sermon of Gita to Arjuna before the Mahabharata. There are depictions of the lives of Lord Buddha and Lord Mahavir scenes from courts of Ashok and Vikramaditya, and other important Indian rulers like Shivaji, Guru Gobind Ji, and Rani Lakshmibai. There is a depiction of Mahatma Gandhi Dandi March, as well as an illustration of Netaji Subhash Chandra Bose. It is worth mentioning here that the Constitution which I have presented to our Honorable Vice Chancellor is a replica of the original Constitution. In the last pages, the document bears the signatures of great leaders who, as members of the Constituent Assembly, were the architects of the wonderful document, notably Dr. Rajendra Prasad, Dr. B.R. Ambedkar, Sardar Patel, Pandit Jawaharlal Nehru, Sarojini Naidu, Zakir Hussain, and many others. Our Constitution is a living document imbued with the pure pulsating energy of a vibrant democratic nation. If the preamble and the chapters on fundamental rights are the soul of the Constitution, and its architecture and schedule its body, then the artwork on its pages are the jewels adorning the beautiful book. I'm proud to present it to our Honorable Vice Chancellor, Professor Nageshwar Rauji, a limited edition of the Oracle calligraphic version of the Constitution of India. I'm sure that the copy will find a place of prominence in his library and be shared and cherished for years to come. Thank you very much.
Thank you, ma'am. It is indeed a sacrosanct occasion because the Constitution empowers us, but we also empower it by following it, by adhering to it, by protecting it, and by preserving it to make it more meaningful and words than deeds. Now I request Professor Sanjay Kamji, Pro Vice Chancellor IGNOU, for his opening remarks.
आदरणीय कुलपति प्रोफेसर नागेश्वर राव, हमारे आज के मुख्य अतिथि और वक्ता श्री पी.के. मल्होत्रा जी, फॉर्मर यूनियन काउंसिल, समकुलपति प्रोफेसर आर.पी. दास, कुल सचिव डॉक्टर बी.बी. नेगी, सभी विधि विद्यापीठ के हमारे उपस्थित निदेशक और शिक्षक बंधु, जैसा कि डॉक्टर सुनील जी ने बताया कि आज का दिन हमारे लिए बहुत महत्वपूर्ण है, और महत्वपूर्ण इसलिए है कि हम आज़ाद तो 15 अगस्त 1947 को हो गए थे, लेकिन जो देश का एक ढांचा बनना था, जो संविधान बनना था, उसकी पूर्ति, उसकी परिणति 26 नवंबर 1950 को हुई, जिसे हम हर वर्ष हर्षोल्लास के साथ मनाते हैं, क्योंकि इसी संविधान ने हमें सामाजिक, आर्थिक और राजनीतिक न्याय, विचार अभिव्यक्ति, विश्वास, धर्म और उपासना की स्वतंत्रता, प्रतिष्ठा और अवसर की समता दी, और इसके अलावा एक जो व्यक्तिगत गरिमा होती है और जो बंधुता की बात भारतवर्ष में है, उन सबको इस संविधान में संजोया गया। और आज जो अपनी बात कहने का अवसर हमें मिलता है एक स्वतंत्र नागरिक के तौर पर, उस स्वतंत्र नागरिक के तौर पर हमें इस बात को लेकर गर्व होता है कि हम भारत के नागरिक हैं और भारतीय संविधान हमारे अधिकारों की रक्षा करती है और हमारे कर्तव्य की याद दिलाती है। आज हम इसी भारतीय संविधान की चर्चा करेंगे और भारतीय संविधान पर विशेष बिंदुओं पर हम प्रकाश डालेंगे। मैंने अभी 2 किताबें पढ़ी हैं। मैं ये चाहता हूं कि जो कानून के जो विशेषज्ञ हैं वो भी इन 2 पुस्तकों पर विचार करें। इंडिया, दैट इज भारत, coloniality, civilization and constitution. This is written by J. Sai Deepak. और दूसरी किताब जो कल ही मुझे मिली है और जिस पर हमने जो भारत का अमृत महोत्सव हम मना रहे हैं, उसमें उन्होंने बताया था वंदे मातरम, जो पुस्तक उन्होंने कंपोज की है, इसलिए मैं कह रहा हूँ कि ग्रामोफोन में जो रिकॉर्ड्स हैं उनके पास इतने रिकॉर्ड के आधार पर और संविधान में जो बहस हुई थी उसके आधार पर उन्होंने लिखा है अखिलेश झा और रश्मि झा। और उसमें एक बात जो पुनर्विचार तो नहीं कहूँगा, लेकिन किस तरह से इसको विद्यार्थियों को पढ़ाया जाए, ये जो हमारे विधि के जो वेत्ता हैं और जो हमारे अध्यापक हैं, क्योंकि एक प्रोफेसर शिवम लाल सक्सेना थे, उन्होंने एक अमेंडमेंट दिया था कि द नेम ऑफ यूनियन शैल बी भारत, और फिर बहस के बाद इंडिया दैट इज भारत ये स्वीकृत हुआ, पारित हुआ। ये जानना हमारे विद्यार्थियों के लिए बहुत जरूरी है। तो मैं ये कह रहा हूँ कि हमारा संविधान बहुत महान है, उसको हमें लगातार उससे प्रेरणा मिलती है, लेकिन जो शोध होंगे, जो कॉन्स्टिट्यूशन पर जो विद्यार्थी शोध करेंगे और संविधान को एक नए नजर से भारतीयता की दृष्टि से यदि हम देखने का एक प्रयास करें, तो हो सकता है कि भविष्य में हमें जो इंडिया भारत है उसके स्थान पर केवल भारत या भारतवर्ष कहने में ज्यादा गर्व महसूस हो, क्योंकि निश्चित रूप से इंडिया कहने में एक औपनिवेशिक जो उसकी भावना है वो औपनिवेशिक भावना नजर आती है। तो मैं एक बार फिर अपने संविधान को प्रणाम करता हूँ, अपनी पूरी आस्था व्यक्त करता हूँ अपने संविधान में, और इसके साथ ही मैं अपना वक्तव्य समाप्त करता हूँ कि ये कार्यक्रम सफल हो और ये बहुत ही दूर दूर तक हमारे विद्यार्थियों तक संदेश पहुंचे। बहुत बहुत धन्यवाद, शुक्रिया।
धन्यवाद सर। I now request Honorable Vice Chancellor IGNOU, Mr. Nageshwar Rao ji, to recite the preamble. We all will be reciting the preamble.
We,
the people of India, have solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote fraternity, assuring the dignity of the individual, and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you.
Thank you, sir. The chief guest of today's program, Shri V.K. Malhotra ji, former Union Law Secretary, who has joined virtually with us, needs no introduction. Shri V.K. Malhotra ji has more than 4 decades of experience in the field of law and has held many important assignments in the Government of India. He was Secretary, Legal Affairs, as well as Legislative Department in the Ministry of Law and Justice, Government of India, Member, Law Commission of India, Presiding Officer and Member, Securities Appellate Tribunal, Chairman, Educated Authority of Money Laundering Act and Judicial Member, Income Tax Appellate Tribunal. Sir has been involved in processing and finalizing many important legislations, including the Criminal Law, Companies Act, Securities Act, and many other social and economic legislations. Sir has been a regular participant in various national level seminars and public debates in important legal issues, constituting panel with several legal luminaries and eminent jurists of the country. Shri Malhotra ji is a recipient of several awards, including National Law Day Award by the International Council of Jurists in 2015, National Law Day Award by the Indian National Bar Association, Award for Leadership in ICT and Cybersecurity in the Government Sector, Award for Outstanding Contribution to Practice of Law in Government Sector by ICCA, Lifetime Achievement Award by ICCA India in 2019. Sir, it is an honor and privilege for us that you are with us today on the Constitution Day celebrations at IGNOU. I now request you to deliver talk on fundamental rights, fundamental duties, and directive principles of state policy. Over to you, sir.
Thank you. Thank you very much. Am I audible?
Yes, sir.
Okay. Thank you. Thank you very much. Thanks for this nice introduction, which I don't know whether I deserve or not. Professor Nageshwar Rao, Vice Chancellor, Indira Gandhi National Open Universities, other dignitaries present here directly through this video conferencing or who have joined through other channels made available by the university. I think when I got a call from Dr. Suneet Srivastav requesting me to speak on the Constitution Day, in fact, I had already made 3 or 4 other commitments. But when I found that such a galaxy of people will be there with whom I will be interacting, I couldn't stop my temptation to say yes. But only thing is that the galaxy which is present here, I don't know the kind of input which you are looking from me, whether I will be able to give you that kind of input with you or not. But definitely, based on my experience as a student of law, working with the Government of India for almost 4 decades, dealing with the legislations at the apex level, the legislation which go to the Parliament have necessarily to be cleared by the Ministry of Law and Justice before they go to the Parliament. I think this is a good platform where I can share some of my experiences, but they should be with reference to the provision of the Constitution, and those provisions of the Constitution which are very, very important because we are meeting on this Constitution Day. In fact, I personally wanted to come to the university and participate in this meeting, but as there are other commitments, so I thought I must make use of the technology. I think we have all become more tech savvy after COVID-19 because most of the things we were not doing through technology. Now we are doing it. And talking about the legal profession, I know the counsels who used to appear in one case on one day, now sitting in the comfort of their office or at home, they attend on the same day a matter in the Supreme Court. On the same day, they attend the High Court matter in Madras, Bangalore, and Chennai also. So I thought, let me make use of this technology and interact with all of you on this important day through technology only. Now, when the country is celebrating Azadi Ka Amrit Mahotsav, and today on this Constitution Day, of course, now I think all of us are familiar with this. But tell me, how many of you were aware of this Constitution Day before 2015? Because it is for the first time in 2015 that the present government issued a notification saying that 26th November will be celebrated as a Constitution Day. For 65 years, it was being celebrated only as a law day, and that celebration was confined only to the people belonging to the legal profession, or maybe in the High Court or in Supreme Court or in the bar associations. We used to have this kind of functioning, giving National Law Day Award and all that, making some speeches, and that was the end of the matter. From 2015 onward, the present government said, no, it should be not be celebrated. It should be a regular, like you celebrate Republic Day or Independence Day. This will be a Constitution Day, and in all government offices, school, colleges, we must recite or read the preamble of the Constitution as the Honorable Vice Chancellor has done right now. And I think that is the right thing to do, because the preamble of the Constitution of India is just like a Gita Sar for the Constitution. Because whatever is written in the preamble of the Constitution, in fact, all provision of the Constitution give effect to these principles which are written in the preamble of the Constitution. Therefore, I thought, let me talk to all of you with regard to the most important part of the Constitution, which protects the rights of the citizens as fundamental rights, impose obligations and duties on the citizens, which were not originally part of the Constitution, but was added in 1976 by 42nd Amendment on the basis of recommendation given by the Swaran Singh Committee report. And the directive principle of state policy, which the states, the legislature and the executive are supposed to carry out to see that the life of the citizens of the country is made more comfortable. They are brought economically, socially at par. Of course, disparities you cannot remove. There cannot be 100% equality, but the kind of disparity which is existing in our system, that need to be reviewed, that need to be reduced. And whether we have been able to do, how much we have been able to do, of course, that may be a topic of discussion on some other platform. But right now, talking about the principle of the Constitution mandates government to do that. And that is why we have made so many welfare legislations. Now, instead of going directly to the fundamental rights, saying that Article 14 says this, Article 21 says this, I can talk about this to the students, but not to the kind of gathering which is sitting here. So what I propose to do is, because I have to maintain the time limitation also, I will refer to the preamble of the Constitution, which all of us have recited right now, and I will try to answer with reference to the experiences which I had while working with the government or while dealing with the legislation as to how important our Constitution is. But before coming to that, as I said, Constitution of India, which is framed by the Constituent Assembly, it was set up by the Cabinet Mission Plan of 1946. All of you must be knowing it. And it held its first meeting on 9th November 1946. And at that time, Dr. Sachidanand Sinha was elected, who was the oldest member of the Assembly, as the provisional president of the Assembly. And on 11th of December 46, the Assembly elected Dr. Rajendra Prasad as its permanent chairman. Then the Constituent Assembly set up 13 committees for framing the Constitution, including a drafting committee under the chairmanship of Dr. B.R. Ambedkar. On the basis of the reports of these committees, a draft of the Constitution was prepared by 7-member drafting committee. And as all of you know, it is the longest written constitution in the world, which originally had 395 articles, 22 parts, and 12 schedules now. Now, this is the largest constitution because it makes many provisions with regard to the areas which may not be relevant for the other countries, but because of the social and economic conditions of our country and the diversity in which we live, because we are a unique example of unity in diversity. Probably it became necessary to make certain provisions, more particularly with regard to the power of the judiciary and the details under which the legislature will be functioning, or with regard to constitution of certain authorities, constitutional bodies like the Finance Commission, like the National Commission for Scheduled Caste, Scheduled Tribe, and all that. They're all part of the constitution, whereas they could have been by a separate legislation also. But the kind of disparity which we wanted to remove under the constitution, they were all included in the constitution. And I think that was a very, very important part of it. Now, the people of India, now I come to the preamble which has been just recited. We, the people of India, having solemnly resolved to constitute India into, who has decided? We, the people of India, have decided, not anybody else. not an outside agency, because after this constitution, even the Government of India Act, which gave us independence, was also repealed. And therefore, this constitution came into force, and we, the people of India, gave this constitution to ourselves and created the organs of the three organs of the government: the legislature, executive, and the judiciary. And all these three organs of the government, they derive their authority from this constitution, and they are supposed to maintain the Lakshman Rekha created under the constitution while discharging their function. And in case they are not observing that Lakshman Rekha, the mechanism of crossing that Lakshman Rekha and how that can be done is also provided in the constitution itself, because the judiciary, which has been empowered to see if the executive is exceeding his jurisdiction or the legislature is exceeding his jurisdiction, then the courts, by the Constitution of India, which has been given by we the people of India, and the courts can reverse the order, they can declare a law unconstitutional. And I give here one example. Right or wrong, no, I'm not on that. I'm on the working of the system as such. And I feel that the system is working by and large very successfully. All of you are aware about the law brought by the government, constitution amendment by the government, amending the constitution by creating a National Judicial Appointment Commission in 2015. It was passed unanimously by the legislature, not a single vote against this particular law. But once it went to the judiciary, and the judiciary, interpreting of the provision of the constitution, said that if this legislation remains, it will violate the basic structure of the constitution, the basic structure theory, which have been laid down by the Supreme Court itself by interpreting the constitution. There is nothing like basic structure written in the constitution. It has come through judicial interpretation, and that power of judicial interpretation is given by the constitution itself. So under this, they said it will destroy the basic structure of the constitution, because the independence of judiciary will be taken away, because the committee which will be selecting the judges, it will be having a representative from the executive also, and outside person who are not part of the judiciary. Now, just a question mark here. Of course, again, that may be a matter of debate, but we will not go into that debate. That once the basic structure theory was not in existence prior to in the constitution itself, and the collegial system of making appointment of judges itself is not provided in the constitution, it is only by way of a judicial interpretation whether striking down of that law by the courts was justified or not is itself a question which is debatable. So I'm only talking about the practical aspect of the working of the constitution. But government, in its wisdom, accepted that judgment, and the previous system, which collegium system, which was established by way of judicial interpretation of the constitution, is still continuing, and the appointments are being made under the judicial system. Now, again, because I'm talking of fundamental rights, fundamental duties, and directive principle, I come back to the preamble of the constitution, because we, the people of India, have given this particular constitution and created these three organs. Now, take, for example, if the legislature is exceeding its jurisdiction, judiciary has not turned down the law, then what happens? That law remains on the statute book, and we, as citizens of India, are governed by that law. And we, the citizens of India, if don't like that law, the power is available to us. Next time when you elect a government, you will elect such a government which will support the ideology or the principles which are acceptable to the individuals, and they can change the government itself. Therefore, in this republic, I come to the second part of the preamble, which says, we, the people of India, we resolve to constitute India into a sovereign, socialist, secular, democratic republic. Just a word of, question here or a caveat here. That word socialist and secular were added by the 42nd Amendment later in 76. But again, because they are part of the preamble, they become basic structure of the constitution, basic feature of the constitution as per the interpretation given by the Supreme Court of India. So our country is sovereign. We don't control, we are not controlled by any outside agency. Our approach is socialistic. We are secular. And why we are secular? We are secular in spite of the fact that the normal terminology of secularism, which is accepted world over, we follow the fundamental principle that the state will not intervene into the religious activities. But at the same time, in the chapter of fundamental rights, we have recognized certain religious practices of certain religion. Therefore, initially this provision word secular was not there, but once we have established that, we thought it is proper that the message should go to the world at large, that we as a country are secular because we respect all religion, we don't discriminate on the basis of religion, and the state doesn't intervene into the or interfere into the religious activities of any person of any religion. Therefore, I come to the next part, and to secure to all its citizens justice. What kind of justice? Justice social, justice economic, and justice political. Of course, the word legal is not here because that is written in the constitution itself. When judiciary administers the law, but in the social, economic, and political justice, I think all the things are covered when we talk about the directive principle of state policy, which are a direction to the state as to when the state is making a law, it must ensure that it is rendering justice social, economic, and political. What for all these labor laws are there? They promote this particular aspect. We have an affirmative, we take affirmative action in favor of the socially and economically weaker section of the society and protect the right of the weaker section of the society, including women, some section of them who are vulnerable, the children who are exploited, as to how their rights are to be protected. All these laws are made to in conformity with this part of the preamble of the Constitution. Now I come to the liberty. Liberty of thought, expression, belief, faith, and worship. If you're talking of this liberty is enshrined in the fundamental rights chapter of the Constitution. When we talk of Article 14, when we talk of Article 19, when we talk of Article 20, 21, and the most importantly, Article 32 of the Constitution, which empowers us to directly approach the Supreme Court in case any of the fundamental right is violated. Now look at the interpretation given by the Supreme Court to Article 21 of the Constitution. If any, for any layman, it is simply you have a right to life. You can live your life. Nobody is going to interfere you. But what kind of life you can live? Look at the interpretation. You can write volumes on the judgment given by the Supreme Court while giving Article 20, while interpreting Article 21 of the Constitution. Right to life does not mean right to life to live in a vegetative state. Right to life means right to education, right to live with dignity, although the right to education now has been separately recognized as a fundamental right. That's a different issue. But when it was not recognized as a separate right, obviously it was part of the right to life. And right to get legal aid, right to get fair access to justice system, right to shelter, right to food, right to fair trial. All these rights have been read into Article 21 of the Constitution. And how it has happened? Because we say that our Constitution is not a normal law. It is the supreme law of the country. And supreme law of the country is not to be given a literal interpretation. The supreme law of the country is the living document, and if it is a living document, it has to be interpreted in accordance with the social and economic needs of the society, and it will not remain the same. There have been times when restrictive interpretation was given. Take for example, during emergency, the fundamental rights to life was even taken away, and even the Supreme Court in the case of ADM Jabalpur versus Shukla said that this right can be taken away. But that was a wrong interpretation of the Constitution. That was not the liberal interpretation of the Constitution. Because in all these fundamental rights, even if they are not even written in the Constitution, do you mean to say that we don't have fundamental rights? Even if they are not written there, they are the human rights which they are inbuilt being a human. And once they are recognized in the Constitution, it is the responsibility and duty of the courts to enforce these rights so that the people in authority don't use their power excessively. Now, take for example, I quote a recent speech of the Chief Justice of India when he was talking about a difference between rule of law and rule by law. I think it is only a person who understands the legal nuances who can differentiate between rule of law and rule by law. And I think all of us, we do understand, but I simply give you an example. Rule by law, when we are talking of the interpretation given to the Constitution, to Article 14, to Article 15, which give affirmative discrimination power under the Constitution, and even with regard to employment in public services under Article 16 of the Constitution, is a principle of rule of law. But when we talk of rule by law, I think some of the examples which have come to our knowledge is when the executive authority exercising their power under the law because the law empowers them, but whether that exercise of power is needed at that particular moment or not, in that particular case or not, is rule by law. Suppose I am a police officer and I find somebody violating the law and I have a power to arrest, I simply say, okay, because I have power to arrest, I am arresting you. But the Supreme Court say, no, if you have to arrest a person, there are certain principles to be finalized. There should be a prima facie case. There should be prima facie evidence available on record. There is a prima facie evidence that he will be violating the law, or he will be jumping the law, or he will run away from the country. Only if these requirements are fulfilled, only then you will be exercising your power. Their instances have come to our notice, not from today, right from day one, that when there are executive persons who are exercising executive authority, and they have, instead of following the rule of law, they have followed rule by law, and the courts, the High Court and the Supreme Court, which enjoy the writ jurisdiction, they have come to the rescue of the common man by giving a relief to them. So I think overall, if I'm talking, I said we have a very vibrant system. Our Constitution is a living document and it confers rights to us and also imposes obligation on the state to pass laws which carry out the objective of the Constitution by avoiding the discrimination which is happening in the society. By and large, I think it is working very well. That is why I always say that Constitution is a living document on all of us, whether we are a student of law or not, as a citizen of this country, must be aware about our rights. But this brings, as a citizen of this country, it casts a duty on us. Everything cannot be done by executive, legislature, or the judiciary. We, the people of India, because we have given this Constitution to ourselves, I think we have certain responsibility, certain duties that as we are exercising our fundamental rights, as we expect the state to remove the economic and social disparity, as we expect the state to help us during crises, including the crisis like COVID-19 pandemic, we expect everything from the government. At the same time, the Constitution places an obligation or duty on us under the Fundamental Duties chapter, which was added by the 42nd Amendment in the Constitution, that we also have certain duties towards the state and towards the fellow citizens. I don't know how many of us are even vigilant about that. I think the time has come when we are expecting a proactive action from the government, which the government do take from time to time. How many of us are aware that I have a fundamental duty also that the system works properly and I'm not creating a hindrance in the working of the section? I'm not very sure how many of us who are sitting and listening to this debate or in other functions where I will be going and participating and harping on this particular point, how many of us are aware that how many fundamental duties are there? We do not respect when somebody is singing national anthem or a national flag is being hosted. We don't give the kind of respect which we deserve it. We have seen in the recent past certain multinational companies playing with the sentiments, our religious sentiments, or violating the norms or the fundamental duties which are imposed on them as a citizen or resident of this particular country. I think this is one area, like now we are saying on Constitution Day, we have to recite preamble so that we are reminded of the principle enshrined in the preamble. And similarly, why can't we also recite and remind ourselves of fundamental duties? I can share my experience when I was in the Law Ministry as Secretary from 2012 to 2016. In the corridors of Ministry of Law, I said, put boards with regard to the fundamental duties as well as with regard to the preamble of the Constitution. So anybody coming to the Law Ministry, at least he will go through it, he will read it. And I think a similar kind of request I would like to make to all of you, that in your educational institution also, of course, we are already doing so far as preamble is concerned. Why can't we propagate the fundamental duties also as a citizen also? We have certain duties. People sitting on Hartal blocking the national highways, how far it is justified? Yes, you have a right, but every right comes with a reasonable restriction. All your freedoms which are given under Article 19 of the Constitution, government can impose a reasonable restriction by law. But why we are looking only for a law for that reasonable restriction to come? Why we should not of our own volition say that, okay, there is a duty, I should not cause an inconvenience to the other person. I should not destroy the public property because that public property has been constructed with my own money, which as a taxpayer, I have paid to the government. I think these are the things on this Constitution Day when we need to talk more about it, educate more our people, the citizenry about it, and I think it should be made a regular part of the curriculum of which we are teaching to our students. I have gone a step further and I am propagating that even for higher education, I think many countries are doing it. We are the largest democracy in the world. We have the biggest constitution in the world. We have, population 65% of the population is below 35 years of age. Why can't we educate that people about all these things? And why can't we make it compulsory? Take, for example, the participation in the disciplined organizations like NCC, NSO, Scouting, making them compulsory that they have to necessarily take part of it. And can it be possible, or is it possible that the government consider that anybody going for a higher education must at least for 1 year serve in this kind of organizations so that a sense of discipline and his loyalty and integrity towards the nation is built during his younger age itself? Probably the kind of corruption which we are looking into the country today. If we really want to remove it, then the kind of integrity which we want to inculcate in our younger generation, sensitizing them about all these constitutional principles becomes very, very important. Another very important step which has been taken, we are talking about all the three organs of the government and the judiciary, what the judiciary is doing, the long delay or the pendency of decisions which take place in the courts. I think all of us are affected by that. Be it a businessman, of course, for commercial activities and for other activities, country is promoting in a big way alternate dispute resolution mechanism. But with that also, with lok adalats, with the legal aid clinics which have been set up, with the arbitration or conciliation set up with the centers which have been set up in the courts, we have not been able to reduce the pendency. Although now with the use of technology also, we are using artificial intelligence also in the rendering of justice, but we have not been able to achieve that objective. But this providing legal aid to the poor section of the society, including the vulnerable sections of the society, I think is a very good step taken by the government under the Legal Services Authority Act, whereby the lok adalats are conducted and the smaller disputes are settled through lok adalat, and the legal aid is provided to those people of those sections of the society who cannot protect their own fundamental rights. I can share one experience with all the participants here when I was law secretary. Mr. Sadanand Gowda used to be the law minister at that time. He received a letter signed by about 450 under trials in Tihar jail, saying that we are serving as an under trial in this Tihar jail for the last 2 to 7 years, different time period. Some of us have already been granted bail, but we belong to that section of the society. Take, for example, dowry cases and all that, all the family members are in jail. We have been asked that we should be released on furnishing a guarantee or surety. We have not been able to furnish our surety. And some of them were such, they have already served the prison, say for 3 years, and the maximum imprisonment that can be awarded to them for the violation or the offense which they have committed is 3 years only. All of us should be released on bail. In spite of our request, nothing has happened. Now the law minister called me and he asked me, Mr. Malhotra, can we do something in this? I told him, well, sir, this is a subject matter which obviously the Home Ministry will take care. We can only tell them that these are the guidelines which you should follow and we should explain. What he told me was, Mr. Malhotra, don't tell me that we should send it to the Home Ministry. It's a question of violation of fundamental rights of all those under trials who are serving jail for such a long time, whose personal liberty is at stake. What are the other way out we can do? We requested the National Legal Service Authorities to come to the Law Ministry. We invited them, discussed the matter with them. National Legal Service Authority took up on themselves this responsibility. They engaged the advocates who are practicing in the courts, paid them a nominal fee. They went to the hard jail, examined each and every case. Applications were moved, and out of those 450 people, about 175 to 200 people, exact number I'm not remembering, they were released within a period of 1 month. So I think for implementation of the law, we have a legal system in place. But for the implementation of the law, the kind of mindset which we need, that mindset is lacking. And probably we have to make aware people about that mindset and see that justice is rendered in this way also. People should take proactive role. And this is what in the legal profession also we say. When you join the legal profession, you don't join legal profession only for the object of earning. You have to do a service to the society. What kind of service? That while earning, you have to see that the fundamental rights of those who cannot protect their own rights are protected through your good offices. And I think that kind of thing also need to be inculcated in the people from the legal profession. And those who are studying law from day one, they should be allowed to participate in the legal aid clinic. They should participate in moot court competition. They should be asked to go and visit jails. They should also asked to go and visit the women homes or the children reform home, so that the law which is enacted by the parliament, that can be implemented in the spirit in which the parliament has enacted these laws. Unfortunately, on that, we are not doing much. For getting a law degree, it's very easy for the students. Pass an examination and you get a law degree. But does that really make you a good advocate? Does that really make you a good counsel? I think that is where this kind of extra legal activities which are required to make them a good citizen, a good professional. And that is how, if the principles which are enshrined in the preamble of the Constitution, and when I'm talking of these rights of social, economic, and political rights, that is why I thought I'll give all these examples. Now come back to the thought of expression liberty, then I come to the equality principle of status and opportunity. And for this equality principle of status and opportunity, I have already mentioned about the Article 15 and 16 of the Constitution. On the one hand, Article 15 says that everybody should be treated equally, but notwithstanding that equality principle, it has been said that for women, vulnerable section of the society, for children, you can make special dispensation or special laws. And that equality can be achieved because equality can be only among equals. Although we talk rule of law, that rule of law means all are to be treated equally, whether it's the prime minister or the lowest man on the lowest rung of the society, they should be treated equally. But for that equality, they have to be equally placed. So only those who are equally placed can be dealt with the same yardstick. Those who are not equally placed, there has to be a legislation for a class. Therefore, class legislation has been permitted by our Constitution, and this class legislation we make for SCs, for STs, for OBCs, even with regard to the employment in public services. And now, of course, there is a talk going on that we should have a reservation for those who cannot secure employment, even in the private sector also. Of course, it is a debatable state because equality principle or the directive principle are direction to the state, not for the individuals. But while making a law, can the state make a law whereby you can ask the private entrepreneurs also to make this kind of reservation, because private entrepreneur basically, after following the corporate social responsibility, work on business principles. If a private corporate person is working on business principle, can we ask him to go for this kind of reservation, which says compromises with my business practices or the profit element, which is one of the main ingredient of running a business. Whereas government as a social entity has to take care of so many things in addition to working as a government. So I think these are the principles which I have learned while working in the government. Many a time I remember when we were going to make a law on surrogacy. There were issues because this particular position is being violated in our country, foreigners coming in this our country and hiring a womb and thereafter running away without taking care of those who have helped them to get a child. I think kind of precautions and preventive measures which need to be taken were not taken up. Child adoption, I think another important issue on which probably the law is not clear in spite of the various judicial pronouncement. Neither we are still complying with the international obligation, nor we have been able to make a law which can be understood by a common man. It is only through judicial interpretation and on case-to-case basis that the decisions are being taken. So once we come to this, if you have to protect the right of the individual, the parliament, the executive, as well as the judiciary has to ensure that the fundamental rights are protected, directive principle of state policy as originally enacted and the amendments which we have made therein, and the chapter with regard to the fundamental duties which have been incorporated in the constitution is properly implemented. And I go back again to the Keshwananda Bharati case, which laid down the basic principles, basic feature of the constitution, that preamble is the basic feature of the constitution, fundamental rights are the basic feature of the constitution. The division of power between the federal structure of is also basic structure of the constitution. Our sovereignty cannot be compromised. And above all, the independent judiciary is also basic structure of the constitution. So we have to work on those lines, and this Constitution Day is a reminder to us that we must follow those principles and we must ensure that the country is governed by rule of law as said by the Chief Justice recently, and it is not governed by rule of law. I can go on and on, but I know I'm discussing this with enlightened participants. I won't take much time of yours. But in case any one of you have any observation to make on what I have said or want any clarification to be made by me, I would leave the floor open for that. With that, I thank you very much, and thanks to all of you for your attention and giving me time, and for your patience also to listening to what I have said. Thank you very much.
Thank you, sir, for the valuable and eye-opening insights, not only on fundamental rights, but fundamental duties as well. And you have given us a food for thought to realize that we are the custodians of our constitution and we must play a meaningful role. I now request Professor Nageshwar Raoji, Honorable Vice Chancellor, Indira Gandhi National Open University, to deliver the presidential address.
PK Alotari, former human laws against the government of India, and my colleagues present over here. A great day on which we all assembled over here Constitution Day. As has been pointed out by Malhotra ji, that this day we started celebrating only from 2015. Earlier, we were talking about the Constitution, and maybe some of us have read the Constitution in small parts while having their primary education, secondary education, or maybe in place of tertiary education. When Mr. Mehrotra was speaking to all of us, I was just remembering my school days when the social sciences had been taught in three small parts: history, geography, and civics. And the civics basics of this Constitution, especially the fundamental rights, that has been taught, and you have learned it, and you have read the examination got good marks. But we never knew that these fundamental rights they are for us. We thought it is in the books, and only the lawyers they know that how the fundamental rights they can exercise. And later on, the fundamental duties. Of course, it has come later. And back to an amendment. But they have made us much more cautious. Along the rights, we are also having some duties. And they were also being important to all of us. Then the role of the state is also being enshrined in the Constitution, directive principles of state policy. And all the three, they are very, very important. To which Mehrotra ji has vividly explained all the three, the relationships amongst these three basics of the Constitution. Further, the way he explained the preamble of the Constitution, this also tells us that how rich is this document. When the Constitution Day, it was being celebrated only among the legal people, then we were not knowing its importance. Now, once it has reached to us, we all started looking into it. Now there is a sense of awareness amongst all of us. Rights, yes. Duties, yes. And what the state will do to support us. They are the basic tenets of our Constitution. That awareness part, it is now becoming visible. Earlier we used to afraid to see the people from law faculty, because I don't know that what sort of provisions they will put on us. But now we all start feeling secure. Rights, duties. The state is also judiciary, executive, then parliamentary, the three wings, they all are there. How the balancing between the three, it is going on to run this country successfully in the last so many years. And this has become a case study for most of the countries in the world, that how the democracy is prevalent in this large system where the people, they reside in different states speaking different languages. Their own cultures, they are distinct. And the languages which they speak, that is also different. But still they all are one. And this is possible because of this constitution. Mehrotraji has rightly said, it is a living document. You read, you look at only one phrase, it will give us appropriate framework of our mind. The way he explained the preamble, and he started analyzing each word which was being used in that preamble. It is really a great learning to all of us. Except 3 to 4 people who are from law. We all are now becoming much more aware about the importance of this constitution. And this is a great beginning. Today, I also feel elevated because when I received the replica of the original document, original constitution from Director School of Law, it's a great honor for me. I have never seen that document earlier. I request even you also, you have not seen it right now. You can see it after this celebration. I could see it, I think this is the second time I have seen it, maybe first time 5 years back. And this is the second time, now it is with me. Ownership, at least for the Vice Chancellor, is there. So, a great document, the wisdom, the legal wisdom, the living document, which has integrated all of us, which has given us a system which is matured enough to keep up our aspirations for the country. Now you see that the importance of this document, how it has integrated all of us. How rights are important. Freedom of speech, right to freedom, right to equality, fundamental rights. And the way Malhotraji has explained to all of us, we all were listening to them, listening to him carefully. And this understanding of the basics of Constitution that will help us to achieve the objectives set for an institution, even for an educational institution also, for which also we are also having some rights, we are also having some duties, and the institution is supposed to provide the principles, the basic principles. And this structure, it has started giving us results. Initially, the pace was slow, and now the pace has become very, very fast. And thereby, we are moving ahead. We started thinking about it. And maybe the School of Law might be thinking that how this Constitution basics it can be spread amongst all of us. We do have a student strength of 35 lakhs. How we can reach to them? Can we have 2 or 3 videos? Crux, maybe Professor Malhotra's lecture, that can be used for reaching to our 35 lakh learners. The basics of the fundamental rights, the basics of the fundamental duties. If that is being spread to all, 35 lakh right now, their own families, it will become 2 crores. The purpose of holding this Constitution Day, it will be served. Because the very purpose of holding this Constitution Day is spreading the awareness of this living document. And we are sitting in an education institution. Our duty is to spread the knowledge. The light of knowledge needs to be spread. Make it simple. Make it easier. Put only the basic things. And those basics that can reach to all in such a language, in such a terminology, where we all can understand from it. Because I do remember as a student, I can't remember anything at that point of time. Somehow I passed the examination. Because at that point of time, we do not know what is this, their significance, their exact meanings. Because the legal language is to be explained for the common people in simpler terminology. Since our institution is Jan Janta Vishwavidyalaya, reaching to the common man, we do have the Swayamprabha channels with us. Make use of that. Make use of those channels to reach to the doorsteps of learners and their families. That is the purpose of holding this Constitution Day. I congratulate all of you on this occasion and wish you all the best. With respect to spreading the awareness regarding the constitutional provisions, as has been outlined by it's a living document, living constitution, and that phrase is very, very important. Thank you very much. Thank you.
Thank you, sir. We are elated by your words, and your guiding force and encouragement has propelled us to spread the basics of Constitution to the fellow citizens. On this very important occasion, Shri Vishwanathan Ji from EMPC has drawn a very beautiful painting highlighting the role of Vikaji Kama in creating the Constitution. I request Vishwanathan Ji to present the painting to the Honorable Vice Chancellor. Thank you, sir. Towards the end, I now request Dr. Anand Gupta from School of Law to propose vote of thanks.
Thank you very much. An attitude of gratitude. Our constitution is not only a legal document, it is a political social document also, and it embodies the ideas, the goals cherished during freedom struggle with regard to social upliftment of the society. And reading of the Constitution for me involves two things: the wisdom of the Constitution makers. When I had the chance to read the debates of the Constitution Assembly, and the kind of wisdom it contains, marvelous. Apart from this, the experience of every generation, which supplements or gives a new meaning to the Constitution, which our forefathers has given to us. There are a number of examples which our new generation has added to the value of the Constitution. My job is to propose a vote of thanks. So I will firstly, जैसा कहते हैं कि अतिथि देवो भव, I first thank Mr. P.K. Malhotra, former law secretary, Government of India. Sir, your presentation reminds me of my teacher who used to say that you can teach the entire Constitution through preamble. And now I thank our Vice Chancellor, sir, our guardian, our patron, who has always guided us. And I thank Professor Satyakant, our Pro-Vice Chancellor, who is a man of literature, and he has his own way of presenting things, and he has always shown interest in our School of Law program. R.K. Das, sir, Pro-Vice Chancellor, who was in charge of our school till recently and guided us on many occasions. Directors of schools, centers, divisions, units, etc. I think all of them. And all the people who are attending this program in the conference room, as well as through our on our Facebook page or other social media. I also thank them for sparing their time. I thank COE people, directors COE, and staff who has provided this conference room to us. Our public information officer, Rajesh Sharma, who has given adequate publicity to this program and arranged its live telecast on Facebook. It is thanking to ourselves, but I thank Director School of Law, Dr. Suni, my colleagues, and the administrative of the School of Law and COE for making this program successful. And I also thank all of those who have directly or indirectly contributed to the success of this program. Thank you very much.
Yes, we come to an end of today's program. Thank you so much.
तो बस एक मामला